I was standing in my driveway in Mesa, Arizona, on a Tuesday morning when a white SUV pulled up to my curb with such aggressive precision that I knew exactly what was coming. Patricia Livingston, president of the Sonoran Vista Homeowners Association, emerged from her vehicle clutching a manila folder like it contained state secrets. Her blonde highlights catching the morning sun as she marched toward me with the determination of someone who had found their life's purpose in making other people miserable. My name is Oliver Kane, and I had lived in this neighborhood for 3 years without incident until about 2 months ago when I decided to set up a small vegetable stand at the end of my driveway. Nothing fancy, just a simple wooden table where I sold tomatoes, cucumbers, lettuce, and whatever else came out of my backyard garden. The Arizona heat was perfect for growing vegetables if you knew what you were doing, and my garden had become so productive that my wife and I could not possibly eat everything ourselves. "Mr. Kane," Patricia said, her voice sharp enough to cut glass. "I assume you received the notice we sent regarding your illegal commercial activity." I had indeed received a letter 3 days prior, informing me that my vegetable stand violated Section 12.4 of the HOA bylaws, which prohibited commercial enterprises within the residential community. The fine was $250, with an additional $50 per day until I removed the offending structure. "I got your letter," I said, keeping my voice level, "but I don't think my vegetable stand qualifies as a commercial enterprise. I'm just selling some extra produce from my garden." Patricia opened her folder with theatrical precision and pulled out a printed copy of the bylaws, already highlighted in neon yellow. Section 12.4 clearly states that no homeowner shall operate any business, trade, or commercial venture from their property. Your stand generates income, therefore it is commercial. "Patricia, I made $40 last week. That barely covers the cost of the seeds and water." "The amount is irrelevant," she said, her mouth forming a tight line that somehow made her look even more severe. "Rules are rules, Mr. Kane. The HOA board voted unanimously to enforce this violation. You have until Friday to remove the stand and pay the fine, or we will be forced to escalate this matter." I felt my jaw tighten. What exactly does escalate mean? Liens, legal action, whatever is necessary to maintain the integrity of our community standards. She tucked the papers back into her folder and turned to leave, then paused. "You know, Mr. Kane, these rules exist for a reason. If we let everyone do whatever they want, property values would plummet. I'm actually trying to protect your investment." After she drove away, I walked back into my house where my wife Tessa was working from home at the kitchen table. She looked up from her laptop, already knowing from my expression that the conversation had not gone well. "Let me guess," she said. "Patricia wants us to shut down the stand and pay a $250 fine for having the audacity to sell tomatoes to our neighbors." Tessa closed her laptop. "That's insane. Mrs. Henderson down the street loves those tomatoes. She told me they reminded her of the ones her grandmother used to grow in New Mexico." "Apparently that doesn't matter." I pulled out my phone and did what any reasonable person in 2025 would do when faced with an unreasonable HOA. I started Googling. What I found over the next several hours was fascinating. Arizona had passed something called the Urban Agriculture Act back in 2021, which specifically protected the rights of homeowners to grow and sell produce from their property. The law had been designed to encourage local food production and give residents more control over their own land. As I read through the statute, my frustration turned into something else entirely: hope. The law stated that no city, town or private entity could prohibit the cultivation and sale of produce grown on residential property, provided certain conditions were met. The produce had to be grown on site. Sales had to be conducted in a manner that did not create traffic hazards or excessive noise, and the operation had to be secondary to the residential use of the property. My little vegetable stand seemed to check every box. I printed out copies of the relevant statute and sent an email to Patricia with the subject line, Vegetable stand violation. In the email, I politely explained that Arizona state law appeared to supersede the HOA's bylaw in this instance, and that I would not be removing my stand or paying any fine. I kept the tone professional but firm, attaching the legal documentation for her review. Her response came less than 20 minutes later, and the brevity spoke volumes. The board's decision stands. We will see you at the hearing. The hearing was scheduled for the following Thursday at 7 in the evening at the community center, a bland stucco building at the center of our subdivision that hosted everything from book clubs to emergency HOA meetings. I spent the intervening days preparing my case like I was arguing before the Supreme Court, printing documents, highlighting relevant passages, and even putting together a PowerPoint presentation, because nothing says I'm serious like visual aids. Tessa offered to come with me for moral support, but I told her one of us should stay home with our 7-year-old son, Marcus. The truth was, I wanted to handle this myself. I had never been the type to back down from a fight when I knew I was right, and everything about this situation felt fundamentally wrong. When I arrived at the community center on Thursday evening, I found the main room arranged like a courtroom, with a long table at the front where the 5 board members sat looking down at rows of chairs for residents. About 30 people had shown up, which surprised me until I realized that my vegetable stand had apparently become a hot topic of neighborhood gossip. Patricia sat in the center of the board table, flanked by 2 men and 2 women I recognized from various neighborhood events, but had never really spoken to. To her right was Donald Mitchum, a retired accountant who always wore polo shirts tucked into khakis. To her left was Sandra Yates, a real estate agent whose face appeared on bus benches throughout Mesa. The other 2 board members were Gary Phillips, who owned a small chain of dry cleaners, and Michelle Torres, a nurse at Banner Desert Medical Center. This hearing will now come to order, Patricia announced, rapping a wooden gavel against the table with more force than necessary. We are here to address the continued violation of community bylaws by Mr. Oliver Kane of 4782 Desert Willow Drive. Mr. Kane has been operating an unauthorized commercial enterprise in direct violation of Section 12.4. She gestured toward me where I sat in the front row. Mr. Kane, you have been given the opportunity to address the board before we move forward with enforcement action. You have 10 minutes. I stood up, my laptop bag slung over my shoulder, and walked to the small podium positioned in front of the board table. I could feel the eyes of my neighbors on my back, and I wondered how many of them thought I was just a troublemaker who should have paid the fine and moved on with my life. Thank you for the opportunity to address the board, I began, opening my laptop and pulling up my presentation. I want to start by saying that I understand the HOA has rules for a reason, and I've always tried to be a good neighbor and follow those rules. However, in this case, I believe the board is attempting to enforce a bylaw that is superseded by Arizona state law. I clicked to my first slide, which showed the text of the Urban Agriculture Act. In 2021, Arizona passed House Bill 2033, also known as the Urban Agriculture Act. This law explicitly states that no city, town, or private entity may prohibit the cultivation and sale of produce grown on residential property. Patricia leaned forward. Mr. Kane, the HOA is a private organization with its own governing documents that all residents agreed to when they purchased their homes. That's correct, I said. But state law supersedes private agreements when those agreements attempt to prohibit something that state law specifically protects. It's the same principle that prevents HOAs from discriminating based on race or religion, even if it's written in their bylaws. Donald Mitchum cleared his throat. Are you comparing selling vegetables to civil rights? I'm comparing the legal hierarchy, I responded, keeping my voice steady. State law is state law, regardless of what our HOA bylaws say, and the Urban Agriculture Act is very clear. Let me read the relevant section. I read directly from the statute, my finger following along on my laptop screen. Quote, no municipality or private entity shall adopt or enforce any ordinance, regulation, or covenant that prohibits the cultivation, transportation, or sale of produce grown on residential property, provided that such activities are secondary to the residential use of the property and do not create a nuisance as defined by state law. End quote. My vegetable stand meets all the criteria specified in the statute, I continued. The produce is grown on my property. The sales are conducted from my driveway without blocking traffic or creating noise, and it's clearly secondary to my use of the property as a residence. I'm not running a grocery store. I'm selling tomatoes a few hours a week. Sandra Yates shuffled through some papers in front of her. But you are generating income, correct? Minimal income, yes. But the statute doesn't prohibit income. It prohibits municipalities and private entities from restricting these activities at all. The legislature specifically wanted to protect urban agriculture and local food production. Patricia's expression had hardened into something resembling concrete. Mr. Kane, I appreciate your research, but the board has consulted with our HOA attorney, and we maintain that our bylaws are valid and enforceable. Then your attorney is wrong, I said, and I heard a few gasps from the audience behind me. With all due respect to the board, if you choose to enforce this fine and attempt to force me to remove my stand, you'll be violating state law, and I will have no choice but to take legal action against the HOA. The room went completely silent. In the 3 years I had lived in Sonoran Vista, I doubted anyone had ever directly challenged the board like this. Patricia's face had turned an interesting shade of pink. Are you threatening this board? She asked, her voice low and dangerous. I'm informing the board of the legal reality, I said. I don't want to sue anyone. I just want to sell my tomatoes without being harassed and fined for doing something that Arizona law explicitly protects. Gary Phillips, who had been quiet until now, spoke up. Patricia, maybe we should table this until we can review the statute he's citing. We don't need to review anything, Patricia snapped. The board has made its decision. Mr. Kane, your fine has now increased to $300 and you have 48 hours to comply. She banged the gavel again. This hearing is adjourned. I stood there for a moment, uncertain whether to feel angry or vindicated. The arbitrary increase in my fine actually strengthened my case because it demonstrated the board's willingness to act punitively rather than legally. As people began filing out of the community center, several neighbors approached me. Mrs. Henderson, an elderly woman who lived 3 houses down, touched my arm gently. I think what you're doing is wonderful, dear. Don't let them bully you. A younger couple I didn't know well introduced themselves as Ryan and Jennifer Morris. We've been wanting to start a garden too, Jennifer said. But we were afraid the HOA would come after us. It's good to know there's a law protecting this. Not everyone was supportive, though. A man named Keith something or other, who I recognized from neighborhood barbecues, shook his head as he passed. "You're going to cost all of us money when our HOA fees go up to pay for the legal battle you're starting." I drove home feeling a complicated mix of emotions. I had expected the board to be reasonable once confronted with the actual law, but Patricia's response suggested this was about more than just bylaws and regulations. This was about control and her unwillingness to admit she might be wrong. When I got home, Tessa was waiting up with a glass of wine already poured for me. "How bad was it?" She increased the fine and gave me 48 hours to comply. "Even after you showed them the law, especially after I showed them the law." I collapsed onto the couch and took a long sip of the wine. "I think I'm going to need a lawyer." The next morning, I started calling attorneys. Most of the ones I contacted weren't interested in taking on an HOA case over a vegetable stand. But finally, I reached someone who not only understood the issue, but seemed genuinely excited about it. His name was Robert Chen, and he had a small practice in downtown Phoenix that specialized in property rights and land use law. When I explained the situation over the phone, he actually laughed. "The Urban Agriculture Act," he said. "I helped draft comments on that bill when it was going through the legislature. HOAs hate it because it limits their authority, but the law is absolutely on your side." "Can you help me?" I asked. "Definitely. This is exactly the kind of case I enjoy." "Let me draft a letter to your HOA board explaining their legal exposure if they continue with this enforcement action. Sometimes all it takes is a strongly worded letter from an attorney to make these boards realize they're on thin ice." We agreed on a flat fee of $500 for the letter and initial consultation, with additional costs if things escalated. It was more money than I wanted to spend, but less than I would pay in HOA fines if I just gave up, and more importantly, it was the principle of the thing. Robert's letter arrived at the HOA board within 3 days, and it was a thing of beauty. 3 pages of carefully cited law and precedent, explaining in precise legal language exactly why the board's actions violated Arizona statute and exposed them to potential liability. He concluded by demanding that the HOA immediately rescind the fine and cease any enforcement action related to my vegetable stand. I also received a copy, and I read it 3 times, feeling a growing sense of satisfaction. This was no longer just me arguing with Patricia in my driveway. This was documented legal representation making a formal demand. The 48-hour deadline came and went. I left my vegetable stand exactly where it was, sold 8 pounds of tomatoes and a bag of cucumbers to various neighbors, and waited to see how the board would respond. They responded with more fines. The letter arrived certified mail, requiring my signature. The HOA was now charging me $300 for the initial violation, plus $50 per day for 5 days of continued noncompliance, bringing my total to $550. The letter also stated that if I did not pay within 10 business days, the HOA would place a lien on my property. "They can't be serious," Tessa said, reading over my shoulder. "Your attorney just explained why they can't do this." "They're either serious or they're calling our bluff to see if we'll actually follow through with legal action." I forwarded the new letter to Robert Chen, and he called me within an hour. "Okay, so they want to play hardball. Here's what we're going to do. I'm going to file a complaint in Maricopa County Superior Court seeking a declaratory judgment that the Urban Agriculture Act prohibits the HOA's actions, along with an injunction preventing them from imposing or collecting these fines. We'll also ask for attorney's fees and costs." "How much is this going to cost?" I asked, though I already knew the answer wasn't going to be cheap. If we can get a quick summary judgment, probably around $3,000. If it drags out or they decide to fight, it could be more. But honestly, Oliver, I think once they see we've actually filed a lawsuit, they'll back down. Most HOA boards are volunteers who don't want the headache or the potential personal liability. Let's do it, I said. I had never sued anyone in my life, but I also had never felt more certain that I was in the right. The lawsuit was filed the following week. Robert called me after leaving the courthouse, sounding pleased. We're on the docket. They'll be served within a few days. I expect we'll hear from their attorney pretty quickly. What we heard instead was that Patricia Livingston was not pleased. She showed up at my house on a Saturday morning, this time accompanied by Donald Mitchum and Sandra Yates. I was in my garage organizing garden tools when I saw them marching up my driveway like an invading force. "Mr. Kane," Patricia said, her voice vibrating with barely controlled fury. "This lawsuit is absolutely ridiculous. You're wasting everyone's time and money over a vegetable stand." "I tried to resolve this without legal action," I said, setting down the rake I'd been holding. "I showed you the law. Your board chose to ignore it." "We have a right to enforce our bylaws," Sandra interjected. "Every homeowner agreed to those bylaws when they bought their property." "Not when those bylaws violate state law," I said. "Look, I don't enjoy this any more than you do, but you gave me no choice." Donald stepped forward, trying to play peacemaker. "What if we compromise? What if you agree to limit the hours you operate the stand and we agree to reduce the fine?" "There should be no fine at all," I said. "I haven't violated any law. I'm exercising my legal rights as a property owner in Arizona." Patricia pointed a finger at me. "You're setting a precedent that's going to turn this neighborhood into a flea market. What's next? Car repair shops? Dog grooming businesses? Those would be actual businesses," I said. "I'm growing vegetables in my backyard and selling what I can't use. The statute is specific about produce cultivation. It doesn't protect other commercial activities." "We'll see what the judge says," Patricia said coldly. She turned and walked back toward the street, the other two board members following behind her. As they left, I noticed several neighbors had come out of their houses to watch the confrontation. The whole situation was taking on a circus-like quality that I hadn't wanted or anticipated. The HOA's response to the lawsuit came 2 weeks later, and it was combative. Their attorney, a firm out of Scottsdale called Morrison and Associates, filed a motion to dismiss, arguing that the HOA's bylaws were a private contract that I had voluntarily agreed to, and that the Urban Agriculture Act didn't apply to homeowner associations. Robert had predicted this exact argument. They're going to claim that HOAs are special because they're private entities, not government bodies. But the statute explicitly includes private entities. The legislature knew exactly what they were doing when they wrote this law. The hearing on the motion to dismiss was scheduled for late September, about 6 weeks after I had first received that initial violation notice. In those 6 weeks, my vegetable stand had become something of a neighborhood cause célèbre. Some residents had started putting up small signs supporting my right to sell produce. Others had placed signs supporting the HOA and calling for respect for community standards. Tessa thought the whole thing was getting out of hand. "It's just vegetables," she said one evening as we watched the news. "Why does it have to become this big dramatic thing?" "Because Patricia made it a big dramatic thing," I said. "I would have been happy to quietly sell my tomatoes and go about my life." Marcus, who had been mostly oblivious to the drama, asked one night at dinner why people were mad at Daddy. Tessa and I exchanged looks, trying to figure out how to explain HOA politics and state law to a 7-year-old. Some people think Daddy shouldn't sell vegetables from our house, I said. But there's a law that says I can, so we're trying to figure it all out. I like when you sell vegetables, Marcus said. Mrs. Henderson always gives me cookies when she comes to buy tomatoes. Out of the mouths of children, I thought. This really should have been that simple. The hearing took place on a Thursday morning at the Maricopa County Superior Court building in downtown Phoenix. I took the day off work and met Robert in the lobby at 8:30. He was carrying a leather briefcase and wearing a sharp navy suit that made me feel underdressed in my khakis and button-down shirt. "Don't worry," he said, reading my expression. "You look fine. This is just a motion hearing, probably 15 minutes tops. The judge will ask some questions, listen to arguments, and take it under advisement." The HOA was represented by a lawyer named Gregory Morrison, a man in his 50s with silver hair and an expensive suit that probably cost more than my entire garden setup. Patricia was there too, sitting in the gallery with Donald and Sandra, all three of them looking grim and determined. The judge assigned to the case was Helen Martinez, a no-nonsense jurist in her 40s who had a reputation for being fair but impatient with frivolous arguments. She called our case right at 9 o'clock. "Morrison and Associates, you filed the motion to dismiss," Judge Martinez said. "Make your argument." Gregory Morrison stood and launched into what sounded like a prepared speech about the sanctity of private contracts and the importance of HOA governance. "Your Honor, when Mr. Kane purchased his property, he voluntarily agreed to be bound by the community's covenants, conditions, and restrictions. These governing documents are essentially a contract between all homeowners in the subdivision. The HOA is simply enforcing the terms of a contract that Mr. Kane agreed to." "What about the Urban Agriculture Act?" Judge Martinez asked, cutting through the rhetoric. "The statute is aimed at municipal regulations, Your Honor. While the language mentions private entities, we believe this was intended to cover things like private land trusts or agricultural cooperatives, not homeowner associations which serve a unique function in residential communities." Judge Martinez turned to Robert. "Counsel, your response." Robert stood up, and I was impressed by how calm and confident he sounded. "Your Honor, the statute could not be clearer. It prohibits any municipality or private entity from restricting the cultivation and sale of produce. The legislature specifically used broad language to include private entities, precisely because they wanted to prevent HOAs from doing exactly what this board is attempting to do." He pulled out a document from his briefcase. "I have here the legislative history and floor debates from when this bill was being considered. Multiple legislators specifically discussed HOAs as an example of private entities that would be covered by the Act. There's no ambiguity here." Judge Martinez took the document and spent several minutes reading it while the courtroom sat in silence. Finally, she looked up. "I'm going to deny the motion to dismiss. The statute appears to cover exactly this type of situation, and Mr. Morrison, your creative interpretation of legislative intent isn't supported by the actual record. We'll proceed to summary judgment motions." "Anything else?" Gregory Morrison stood again. "Your Honor, the HOA would like to request a stay of Mr. Kane's activities pending resolution of this case." "On what grounds?" Judge Martinez asked. "The ongoing violation of community bylaws is causing disruption and setting a precedent that could undermine the HOA's authority across numerous other areas." "Denied," Judge Martinez said flatly. "Mr. Kane has a colorable claim that his activities are protected by state law." I'm not going to shut down his vegetable stand while this case is pending. Anything else? No. We're adjourned. The whole thing had taken less than 20 minutes, but I felt like I'd just won the lottery. Robert turned to me with a satisfied expression. That went about as well as it could have possibly gone. As we left the courtroom, I could see Patricia conferring urgently with Gregory Morrison in the hallway. She looked up as I passed, and her expression was pure venom. "This isn't over," she said. "Apparently not," I replied. See you at summary judgment. Over the next few weeks, things in the neighborhood got weird. Someone started leaving angry notes on my windshield about being a troublemaker and lowering property values. I couldn't prove it was Patricia or one of the board members, but the timing was suspicious. More concerning was when I came home one afternoon to find my vegetable stand had been knocked over, the tomatoes scattered across the driveway and crushed. Tessa had been home when it happened and said she heard a crash, but by the time she looked outside, there was no one around. I filed a police report, though I knew they probably wouldn't be able to do much about some smashed tomatoes. The officer who took the report was sympathetic but realistic. Could have been kids, could have been someone with a grudge. Without witnesses or camera footage, there's not much we can investigate. "I'm getting a security camera," I told Tessa that evening as we cleaned up the mess. "Maybe we should just stop," she said quietly. "Is it really worth all this stress and conflict?" I understood where she was coming from. The lawsuit, the neighborhood tension, and now vandalism. It would have been easy to just pack up the stand and move on with our lives, but something about the fundamental unfairness of the situation made me stubborn. "It's about more than vegetables," I said. "If the HOA can ignore state law on this, what else can they get away with? What happens when they decide your flower garden is too big or our Christmas lights are the wrong color?" she sighed. "I know, you're right. It's just exhausting." I installed 2 security cameras the next day, one covering the driveway and one covering the backyard. They were Wi-Fi enabled and sent alerts to my phone whenever they detected motion. I felt ridiculous having to protect a vegetable stand with surveillance equipment. But after the vandalism, I wasn't taking chances. The cameras proved their worth 3 days later when they caught Patricia Livingston herself approaching my stand at 6 in the morning. I was at work when I got the motion alert on my phone. I pulled up the live feed and watched as she stood there examining the stand, taking photos with her phone from multiple angles. She didn't damage anything, but the fact that she was there at all, clearly documenting something for use against me, felt invasive and creepy. I sent the footage to Robert Chen with a note. "This is the HOA president. Not sure if this is relevant but wanted you to have it." He called me within an hour. "This is actually very helpful. It demonstrates their continued focus on your stand despite the pending litigation. I'm going to include this in our motion for summary judgment to show the pattern of harassment." The summary judgment motions were filed in late October. Both sides were essentially asking the judge to rule in their favor without going to a full trial, arguing that there were no disputed facts, and the law clearly supported their position. Robert's motion was comprehensive, laying out the statute, the legislative history, the plain language that protected my rights, and the HOA's continued efforts to punish me despite the law. Gregory Morrison's opposing motion argued largely the same points he had made before, trying to carve out an exception for HOAs based on their unique role in residential communities. The hearing was scheduled for mid-November, but something interesting happened a week before we were supposed to appear in court. Gregory Morrison called Robert to discuss settlement. "They want to talk," I said when Robert called to tell me. "What changed?" "My guess is Morrison finally convinced the board that they're going to lose, and losing means they'll have to pay your attorney's fees on top of their own. He's proposing that the HOA rescinds all fines, admits the Urban Agriculture Act applies, and agrees not to enforce their commercial activity bylaw against you or any other resident engaged in produce sales. That sounds like everything we wanted, I said. Almost everything. He's not offering any damages or compensation for your time and trouble. I don't care about damages, I said. I just want to sell my vegetables without being harassed. There's one other thing, Robert said. He wants a confidentiality clause. They don't want you talking about the case or the settlement. Absolutely not, I said immediately. Other homeowners should know about this. If someone else wants to start a garden and sell produce, they should know they have that right. That's what I figured you'd say. I'll tell him confidentiality is a deal breaker. The negotiations went back and forth for several days. The HOA initially insisted on confidentiality, then proposed limiting my ability to make public statements about the board members personally. Robert pushed back, and eventually they dropped the confidentiality demand entirely. The final settlement agreement was signed on November 12th, almost 3 months after Patricia had first shown up in my driveway with her manila folder. The terms were simple. All fines were rescinded. The HOA acknowledged that the Urban Agriculture Act protected my right to sell produce from my property, and the board agreed to amend their bylaws to comply with state law. Additionally, the HOA would pay $3,000 toward my attorney's fees. I had won. The victory felt strange, though. I had expected to feel more triumphant, but mostly I just felt tired and relieved that the fight was over. When I told Tessa the news, she hugged me and said, "Thank God. Can we please just go back to being boring neighbors now?" "That's the plan," I said. The HOA sent out a newsletter to all residents a few days later, announcing the settlement and the bylaw amendment in the blandest possible language. There was no apology, no acknowledgement that they had been wrong, just a dry notice that the commercial activity bylaw had been amended to comply with state agricultural statutes. Patricia Livingston's name was absent from the newsletter. I heard through neighborhood gossip that she had resigned from the board shortly after the settlement was finalized, claiming she needed to focus on personal matters. Donald Mitchum had taken over as president. About a week after the settlement, I was outside working on my vegetable stand when Donald approached me. He looked uncomfortable, his hands shoved in his pockets. "Oliver, I wanted to apologize," he said. "The board should have listened when you first brought up the statute. Patricia was just so convinced that we needed to enforce the bylaws, and the rest of us went along with it. I'm sorry we put you through all that. I appreciated the apology, even though it came late." "Thanks, Donald. I know board members are volunteers just trying to maintain the neighborhood." "I get it. For what it's worth, I tried your tomatoes," he said with a slight smile. "My wife bought some last week. They're really good." After he left, I stood there looking at my simple wooden vegetable stand, thinking about everything it had cost to defend something so basic. But I also thought about the other neighbors who had expressed interest in starting their own gardens, and the young couple who had thanked me for standing up to the board. And I realized the fight had been worth it. Mrs. Henderson came by that afternoon to buy tomatoes, and as always, she brought cookies for Marcus. "I'm so glad you won, dear," she said. "My late husband always said that standing up for what's right is never wasted effort, even when it's hard." The holidays came and went. My vegetable stand continued operating through the winter, though sales slowed down as my garden produced less in the cooler months. I started planning for spring, thinking about expanding my garden beds and maybe adding some fruit trees. In January, I noticed another vegetable stand had appeared 3 streets over, run by a young family I didn't know well. I walked over one Saturday morning and introduced myself to the husband, whose name was Carlos. "I wanted to thank you," he said. "We heard about your case with the HOA. We had been wanting to do this for a year, but were too scared. When we heard you won, we figured it was finally safe. Just growing food and selling to neighbors," I said. "The way it should be." His wife, Maria, came out carrying their toddler. "We're trying to teach our daughter where food comes from. So much of what's in the store is shipped from thousands of miles away. There's something special about knowing your tomatoes grew right here." I couldn't have said it better myself. As winter turned to spring, my garden exploded with new growth. The tomato plants I had started from seed in February were beginning to produce fruit by April. The cucumber vines were climbing their trellises, and the lettuce was so abundant I was giving it away to anyone who would take it. The vegetable stand became a regular part of the neighborhood rhythm. People would stop by after work or on Saturday mornings, buying whatever was available and chatting about their own gardens or asking for growing tips. It became less about the money, which was still minimal, and more about the community connection. Tessa started baking bread to sell alongside the vegetables, reasoning that if I could sell produce, she could sell her homemade sourdough loaves. The bread was a huge hit, and suddenly our little stand was generating actual modest income. We joked about quitting our jobs and becoming full-time urban farmers, though we both knew that would never happen. In May, the local newspaper ran a story about the growing trend of neighborhood produce stands in Mesa and other Phoenix suburbs. The reporter interviewed me about my case against the HOA, and I explained the Urban Agriculture Act and how it protected homeowners' rights. "The law recognizes that local food production is good for communities," I told the reporter. "It reduces transportation costs, gives people access to fresh produce, and helps neighbors connect with each other. HOAs shouldn't be able to override those benefits just because it doesn't fit their aesthetic preferences." The article ran on a Sunday with a photo of me standing next to my vegetable stand, holding a basket of tomatoes. The headline read, "Urban Farmers Fight HOAs for Right to Sell Homegrown Produce." It was picked up by a few other outlets, and for a brief moment, I was a minor local celebrity. The attention brought more customers, including people from outside the neighborhood who had read the article and wanted to support the cause. One woman drove from Tempe just to buy tomatoes and tell me she was fighting a similar battle with her own HOA. "My board says my raised garden beds are unsightly," she said. "But I showed them the article about your case, and they backed down. Thank you for fighting this." These interactions reminded me why the fight had mattered. It wasn't just about my right to sell vegetables. It was about pushing back against the creeping control that HOAs exerted over every aspect of residential life, often without proper legal authority. Summer in Arizona is brutal for most vegetables, but I had learned to grow heat-tolerant varieties that thrived even when temperatures soared above 110 degrees. Armenian cucumbers, desert-adapted tomatoes, and various peppers became my main offerings during July and August. One particularly hot afternoon in August, almost exactly a year after Patricia had first confronted me about the vegetable stand, I was sitting in the shade of my garage with a cold drink when an unfamiliar car pulled up. A woman in her 30s got out, introduced herself as Jennifer Wu, and explained she was an attorney with the Arizona chapter of the Institute for Justice. "We're a nonprofit that litigates property rights cases," she said. "I read about your case, and I wanted to talk to you about helping us develop some educational materials for homeowners dealing with HOA overreach." I invited her to sit down, and we talked for over an hour about the specifics of my case, the Urban Agriculture Act, and the broader patterns of HOA abuse that she saw in her work. "The problem is that most people don't know their rights," Jennifer explained. HOAs send threatening letters, impose fines, and homeowners just comply because they assume the HOA has unlimited authority. But state law actually limits HOA power in a lot of ways that people don't realize. She wanted to create a guide specifically about urban agriculture and HOA restrictions, using my case as an example. I agreed to help, figuring that if my experience could help other people avoid similar fights, it would be worth the time. The guide was published online in September and distributed to homeowner advocacy groups throughout Arizona. It laid out the Urban Agriculture Act in plain language, explained how to respond if an HOA tried to restrict produce cultivation or sales, and included sample letters homeowners could send to their boards. Robert Chen, my attorney, contributed a section about when to involve legal counsel and what to expect from the litigation process. The whole thing was practical and empowering, exactly the kind of resource I wished I had found when Patricia first handed me that violation notice. As autumn arrived and the weather cooled, my garden entered its most productive season. The summer heat broke, and suddenly everything grew with renewed vigor. My vegetable stand was overflowing with tomatoes, peppers, squash, and herbs. Marcus had started helping out, learning to count change and interact with customers. He loved the responsibility, and Tessa said it was teaching him valuable lessons about work and money. When he used his earnings to buy a new video game, he proudly announced at dinner that he had earned it himself by working at Daddy's vegetable stand. In October, I got a surprise email from Donald Mitchum, who was still serving as HOA president. He asked if I would be willing to serve on a committee to revise the community bylaws to ensure they complied with current Arizona law. The board had realized during my case that their governing documents were outdated in several ways, and they wanted to do a comprehensive review. I was hesitant at first, not eager to spend my free time in HOA meetings after everything that had happened. But Tessa pointed out that having a voice in shaping the rules was better than being subject to rules I had no input on. I agreed to join the committee. The committee met twice a month for 3 months, reviewing every section of the bylaws against current Arizona statutes. We found several other areas where the HOA's rules were potentially problematic, including restrictions on solar panels that conflicted with state renewable energy laws, and parking rules that might violate disability accommodation requirements. The process was tedious but surprisingly rewarding. The other committee members were reasonable people who genuinely wanted to do the right thing. Without Patricia's combative presence, the board functioned much more collaboratively. We presented our proposed revisions to the full HOA membership in January at an annual meeting. There was some pushback from a few residents who felt we were weakening the board's authority, but the majority of homeowners supported the changes. The new bylaws were approved by a vote of 68%, well above the required majority. As I sat in that meeting, watching my neighbors vote to adopt rules that recognized their rights as property owners, I felt a sense of completion. The fight over my vegetable stand had evolved into something bigger, a genuine improvement in how our community was governed. Spring came again, and I was planting tomato seedlings for what would be my 3rd season operating the vegetable stand. I had expanded the garden beds, added a small greenhouse for starting seeds, and invested in better irrigation equipment. What had started as a way to use excess produce had become a genuine passion. Tessa's bread sales had grown too, and she was experimenting with different varieties of sourdough and artisan loaves. We joked that we had accidentally started a small business, but the truth was we both enjoyed the connection it gave us to our community. The neighborhood had changed in subtle ways since that first confrontation with Patricia. There were now 5 different produce stands operating within Sonoran Vista, each with their own specialties and regular customers. The board had even organized a neighborhood harvest festival in the fall, celebrating local food production. Mrs. Henderson still came by regularly for tomatoes, always bringing cookies for Marcus, who was now 8 and had become quite the little salesman. Carlos and Maria from 3 streets over had become good friends, and our families often got together for dinners featuring food we had all grown ourselves. In March, I received an email from a homeowner in Tucson who had found my information through the Institute for Justice Guide. She was facing HOA fines for her vegetable garden and wanted advice. I spent an hour on the phone with her, walking through the same arguments I had made, and connected her with Robert Chen, who agreed to send a letter to her HOA. Her case resolved quickly, the board backing down as soon as they realized the law wasn't on their side. She sent me a thank you note with photos of her garden, expressing gratitude that someone had fought this fight so she didn't have to. These moments reminded me that standing up to Patricia and the board had ripple effects beyond my own situation. Every person who avoided a similar fight, every HOA that thought twice before imposing unreasonable restrictions, every neighbor who started a garden knowing their rights were protected, all of it traced back to that choice I had made to print out the Urban Agriculture Act and refuse to back down. On a warm Saturday morning in April, I was arranging tomatoes on the vegetable stand when I saw Patricia Livingston drive past. She had moved out of Sonoran Vista a few months earlier, but apparently still had reasons to come through the neighborhood. She slowed down as she passed my house, looking at the stand that was bigger and more successful than ever, and then drove on without stopping. I felt no animosity toward her, just a vague sense of pity. She had invested so much energy into controlling something that didn't need controlling, and in the process had made herself miserable and alienated her neighbors. There was probably a lesson in that about the dangers of petty authority and the importance of knowing when rules matter and when they are just about ego. Marcus came running out of the house. "Dad, Mrs. Henderson is here for tomatoes. Should I help her?" "Absolutely, buddy. You know what she likes." I watched my son carefully select the ripest tomatoes, counting them into a bag and chatting with Mrs. Henderson about his little league games. This was what the fight had been about. Not just the right to sell vegetables, but the right to use our property in reasonable ways that benefited our family and our community. The right to teach my son about work and responsibility. The right to connect with neighbors over something as simple and fundamental as homegrown food. The legal bills had been worth it. The stress had been worth it. The neighborhood drama had been worth it. Because in the end, we had won not just the case, but the larger battle for common sense and community over arbitrary rules and petty enforcement. As summer approached and the temperatures started climbing back toward triple digits, I was already planning for next season. I wanted to try growing some fruit trees, maybe add a berry patch. Tessa was talking about building a proper outdoor oven for her bread baking. We had turned a simple vegetable stand into something that brought us joy and brought our neighbors together. The HOA never bothered us again. The new board respected the boundaries of their authority and focused on actual community issues like street maintenance and common area landscaping. The neighborhood was peaceful, friendly, and more connected than it had been when Patricia was in charge. On a quiet evening in May, I sat on my front porch watching the sun set over the desert mountains, a glass of iced tea sweating in the heat. The vegetable stand was closed for the day, the garden was watered and thriving, and Tessa was inside helping Marcus with homework. Everything was exactly as it should be. My phone buzzed with an email from Jennifer Wu at the Institute for Justice. Another homeowner victory against an HOA, this time in Flagstaff, with a couple who had used our guide to defend their backyard garden. She included a photo of them standing proudly next to their raised beds, holding a copy of the Urban Agriculture Act. I smiled and forwarded the email to Robert Chen with a note. "Another one bites the dust." His response came quickly. "HOAs learning they can't override state law. About time." The fight over my vegetable stand had become part of a larger movement of homeowners reclaiming their property rights from overreaching community associations. It wasn't revolutionary or dramatic, just ordinary people insisting on their right to grow food and sell excess produce without permission from a board of volunteers with inflated senses of authority. As darkness fell and the stars emerged in the desert sky, I thought about all the unexpected places a simple vegetable stand had taken me. Legal battles, newspaper articles, helping strangers fight their own HOA disputes, even serving on the committee that rewrote our community bylaws. None of it had been part of any plan. I had just wanted to sell some tomatoes, but sometimes standing your ground on small things leads to larger changes. Sometimes refusing to back down when you know you're right creates space for other people to stand up too. Sometimes a vegetable stand is more than just a vegetable stand. It is a test of whether we own our property or merely rent it from HOAs with the authority to dictate every detail of how we live. I had passed that test. More importantly, I had helped other people pass it too. And that, more than any legal victory or settled fine, made the whole ordeal worthwhile. My vegetable stand would be open tomorrow morning, selling tomatoes to neighbors in defiance of what Patricia Livingston had once insisted was impossible. And it would be open the morning after that, and the morning after that, for as long as I wanted to keep growing food and connecting with my community. The law was on my side. The neighborhood supported me, and my family was thriving. Patricia was gone. The HOA had learned its limits, and somewhere in Flagstaff, another couple was growing vegetables without fear. Justice, I thought, sometimes looks like tomatoes on a wooden stand at the end of a suburban driveway, and that was just fine with me.